Okay, I think we are going to go ahead and get started with our afternoon panel. The afternoon panel is on movement lawyering, centering impacted communities. Movement lawyering. Oh, all right, hold on. Movement lawyering. Okay, so. The T-shirt says revolutionary. What does it say down here?
Empowering the masses.
Yeah, empowering the masses. So that's movement lawyering. That's what we're going to be doing. That's what the panel is going to be talking about. Thank you, Avi. All right, so now I can introduce the panel. Here is our panel for empowering the masses for movement lawyering. They will have their own, Avi will be their facilitator as well as a panel member. Avi Singh, you heard a little bit about Avi during our morning panel. He has been a deputy public defender with the Office of the Public Defender in Santa Clara County since 2009. He's a graduate of UC Davis and Harvard Law School. He currently supervises the Public Defender's Research Unit. He also teaches advanced trial techniques at Santa Clara University School of Law, and he's worked collaboratively with community organizations in his courtroom advocacy. He's also worked why did you put that in your bio? He has also worked collaboratively with the Criminal Defense Clinic. Avi Singh. Our next panelist, Ashante Mitchell. Ashante is a deputy state public defender in the capacity building unit of the Indigent Defense Improvement Division. This is actually new. Ashante may talk more about this new position and this important new area of state funding. Ashante is a graduate of the University of California, Berkeley, and of Georgetown's Law Center, the Georgetown University Law Center. Prior to joining IDID, he was an attorney with the Public Defender's Office in Santa Clara County for over a decade. As a trial attorney, Ashante has litigated both juvenile and adult cases. He also helped to successfully launch the first community outreach attorney position at the Public Defender's Office. And in that role, he embedded himself in homeless encampments, and he helped to establish a network of community-based organizations that address the needs of unhoused persons and reduced their involvement in the criminal legal system. He also worked with students, teachers, and school administrators to prevent suspensions, expulsions, and juvenile court involvement, working to disrupt that school-to-prison pipeline. Mr. Mitchell has also taught at Santa Clara University Law School as a lecturer in trial techniques, and in his free time, whatever that means, he enjoys riding his motorcycle and listening to live music. Ashante Mitchell. And our third panelist, Karina Alvarez. Karina is the racial justice attorney for the Santa Clara County Public Defender's Office, a relatively new and exciting position, I will add. I'm really pleased, and she has worked together with the Criminal Defense Clinic and with our Racial Justice Pilot Project in that capacity as well. Karina litigated one of the first RJA motions in the county of Santa Clara in 2021. Currently, she handles RJA data collection, data analysis, and case preparation. Maybe she'll have the chance to talk with you about that data analysis and collection, which is so key to RJA work. She's been a public defender for over 7 years, and her past assignments include misdemeanors, felonies, and conservatorships. She's on the Diversity, Equity, Inclusion, and Belonging Committee, and she enjoys mentoring new attorneys. And with that, I turn it over to the panel. Thank you all for being here.
Thank you.
Although I did not say, I asked Karina to write this down, and then I just didn't even say it. The other two panelists had indicated their education. Karina was a graduate of UC Santa Barbara for her undergraduate degree and Golden Gate Law School for her JD. Thank you again, Karina.
Well, thanks so much, Ron, for having us and for everybody attending. We're going to start by just talking a little bit about who we are outside of our bios in connection with movement lawyering. kind of the ways in which we might have had some limited contact with it to start. Then we're going to talk through some definitions. We can distribute these afterward and have kind of reactions to those definitions and the ideas that follow those definitions, and connect it to what's possible in our practices. So Karina, why don't we just get started with maybe some what brings you, or what you think of when you come to a movement lawyer panel to start.
Yeah, so a little bit about me that I didn't mention in my bio that I think is connected to movement lawyering. So when I first graduated college, I didn't go to law school right away. I was really interested in human rights. And I worked with a human rights group in Argentina called Madres de Mayo. It was to help mothers and people that had political prisoners and loved ones that disappeared. So I saw firsthand what it was like to be a part of a movement, but I also saw a lot of frustrations with the inability to really effectuate change. So there was a lot of social services, but there wasn't a lot of change effectuated. And I think that, coupled with some work I did with Amnesty International, specifically attorneys there, made me realize that the marriage of a movement with lawyering could be really powerful. And even though at the time I didn't know that was called movement lawyering, I now do. So in my racial justice work, I work with the Racial Justice Act, which is codified in Penal Code 745, and it really is the marriage of a movement with the law. So the movement being racial justice for all, the elimination of bias, the eradication of implicit bias and explicit bias in the legal system. For the first time, we have a legal avenue to explore relief for clients. So that's how I consider myself working in movement lawyering currently.
So my name is Ashante Mitchell. I think when I thought about the idea of movement lawyering, it was I think a beautiful framework for the work that we do as defenders. I think just by virtue of representing clients and being on this mission to end mass incarceration, we are naturally and automatically embedded in that social movement. So it's kind of just it's part and parcel of what we do. I think we all do it in different ways. I think one of the things that stood out to me in my work at Santa Clara County, as Professor Tyler mentioned, was being involved in the community outreach program. I can't take credit for the idea. It was not, it wasn't something that I came up with, but it was something that I helped to launch and build and develop. And it was the idea that there is a gap between the courtroom and the work that we do on behalf of our clients in front of judges and the community members and people in the community. So the idea was to figure out a way to connect and to bridge that gap and to do work outside of the courtroom, which involved going outside, going into homeless shelters, going into homeless encampments, going into schools, working with youth, and really being creative and allowing the community to kind of lead those efforts. And so when I do think about movement lawyering, I don't think I thought about it at the time that I was doing that work and launching that program. I think I framed it as educating and helping folks. But I think when I look back on it and I think about how I approach the work going forward, it really is about empowering the community and kind of transferring some of that power back to the community outside of the courtrooms, so that they have the knowledge and the education to also advocate for themselves with their attorneys.
I'll start with, we'll talk about a few other things, but my connection started in relationship to an idea called participatory defense, which is communities engaging in this criminal court process and taking the power and kind of models of community organizing and then connecting them to what's happening in immigration courts, but for me, what's happening in criminal courts. And my first interaction with it was as a misdemeanor attorney. I was representing somebody charged with a crime, and they had an immigration process going on where they were tied with a community organization called Silicon Valley Debug. And so I was having a meeting with the attorneys, and then community members were at the meeting. And it seemed kind of concerning to me as a misdemeanor attorney, like attorney-client privilege, it's breached. These people are going to be called as witnesses to testify. I'm going to surrender my bar card before I've even, tried a couple cases or whatever. And so we had that call, and then I was, flash forward, I'm doing jury selection, and there's a big crowd of people, and they're all leaving, and this guy comes up to me, and I think he's a juror, and I'm like, I can't talk to you, sir. And he's like, I'm Raj with Debug, and they showed up. They were being there for our client, but at the same time, right, there was, concern or hostility on my part. I'm in the middle of the trial, like I'm doing what I'm supposed to do. Are you really fighting for him or whatever? That's not what he said, but that was how I was interpreting it through these defensiveness of like, I'm in control of the case, right? Which I don't hold that view now. So flash forward, I was representing a person who was shot by the police and then charged with assaulting the police. And it was a very high, it was just tough. It was just a really tough litigation. It was terrible what happened to him. It was terrible. It was incarceration. It was terrible how like everything was being filtered through like his dangerousness and how he was wrong and how all the bad stuff. And he was totally isolated. And I had known Raj, and we had built a really strong relationship, and with his colleagues too. I would go to meetings and stuff like that. And I talked to him about how I needed, I just needed his help and their group's help, just about the isolation component, and that somebody should show up for Henry, the person I was representing, and his family. His mom would come to court, and she'd just be devastated. She was carrying, she was riding the bus, from San Jose to Martinez, right, to take care of stuff. She was handling grandchildren. She was handling everything, and then she had to carry this weight. And so I just wanted some help for her, right, the family members of the people that I represent. I wanted something for them. And they were already doing it, right? There were these people already doing it. And not only did they take her in and put his name up on a whiteboard and talk through what was going on in the case, but they showed up like every time. And like the feeling that I have is that like injustices like really fester and thrive and are built up in like isolation, empty courtrooms. And they kind of took that and ran with it. So they started a campaign about almost a hashtag, because he could have been a hashtag, but for his survival, right? And you look at the bullet trajectories, and they were all around his body, And I just saw the power that organizing model had. And it made me think just much more about how that limited approach of, that essential approach of client-centeredness, right? That's essential. But client-centeredness to the exclusion of community engagement and empowerment doesn't have to be the case. If it's at odds, then sure, it has to be the case. But most of the time, it's not. So that informs what I do with my practice. And I think everyone should seek it out where it makes sense for their clients. Okay. So we're going to move to actually defining movement lawyering. And we're going to have a couple definitions, and I'm going to ask this group to respond to those. And if you have any responses, remember what we're talking about, and then we'll talk about it. So doing research for this, I came across this Ella Baker quote, right? And Ella Baker Center does amazing work all over the place, especially in California, on reform, on advocacy. And so here's the quote from Ella Baker. In order for us as poor and oppressed people to become part of a society that is meaningful, the system under which we now exist has to be radically changed. This means that we're going to have to learn to think in radical terms. I use the term radical in its original meaning, getting down to and understanding the root causes. It means facing a system that does not lend itself to your needs and devising means by which you can change the system. So like public defenders, we work in a system that does not meet our clients' needs at all. It doesn't solve any root cause problems. It's like, it's criminogenic, right? It causes more harm than it solves. It does all sorts of bad stuff. And thinking about kind of the shape of it and how it operates and starting to do something different and kind of imagine a different world and bring that into being. So Karina and Ashante, do you have any reactions to that part of the, that language in connection with your movement lawyering practice?
Go ahead.
Yeah, that quote really resonates. I think that as public defenders, specifically at our office, Santa Clara Public Defender, we really try to follow a holistic defense model. So that means that rather than looking at my client as a docket number or even his name with the associated charge, I'm looking at him as a whole. So who is he in the community? What is his family like? Does he have a job? What is that job? Are there immigration consequences? Where does he come from? What does that say about his current situation? Is he a refugee? So I think that has to really shape, and not only shape, but really lead our next steps as attorneys. And I think part of movement lawyering, for me, what really resonates is letting the voices of the oppressed lead our work. So rather than coming into a case and looking at it from a purely legal standpoint of, okay, this is what he's charged with, these are the defenses that could be, I see my role as twofold. I see my role as an advocate for him and as his attorney, and I'm going to take the steps that are best for him and everything that I mentioned before, so every aspect of his life. And I'm going to talk to him about that, and he's going to tell me what his needs are. But the other part of this is that I really see our role as educators. So when I have, even during arraignment court, for example, when I have like 10 minutes or 6 minutes to talk to somebody, I see my role as an educator. So whereas I'm only going to look at his charge in some cases, I would rather look at his charge, see what defenses, inform him of his legal rights, but also inform him of his legal rights as it pertains to the big picture. So do you have immigration concerns? These are the immigration relief avenues that are available to you. Let me make a call to your immigration attorney, things like that. Even so much as living conditions. I want him or her or them to have the opportunity to speak to an attorney, not just about their case, but holistically. So that quote really resonates again because I think being radical and getting again to that root definition of the word is to try our very best to let these communities lead us into a way that we can best help them while recognizing that as attorneys, we have also operated in a system that has oppressed many. So recognizing that our roles as attorneys historically has been complicit in that oppression and really deviating from that.
Yeah, I think I would piggyback off of what Karina was saying. I think that piece of it really resonates with me also in terms of thinking radically and thinking about ways to change the systems. We know that as defenders, we come into a system that has historically been oppressive. I remember there was one distinct time walking back from court and a random person stopped me and was like, hey, are you an attorney? How do you feel? Do you feel like it's beating you down from when you were in law school, or do you feel like you've been able to change the system? And it made me reflect on the cover letter or personal statement I wrote for law school, and the final line was like, I want to change the world. That's why I wanted to go to law school. But you come into an organization or you come into a courtroom and there's a status quo, and there's ways that things are done. Before RJA, and it's really cool to be on this panel because I do feel like these are folks that are kind of pushing the envelope in terms of changing systems. But I remember as a young attorney, it was difficult to bring up race in the courtroom, and not everyone did it, even though it should have been done. It was difficult for me to do. And I remember there were attorneys who did it anyways, even though it kind of was like dropping a bomb in the courtroom. And so to me, that's thinking radically, that's looking at a system that is unfair, racist, and oppressive, and saying, I'm gonna name that and call it out for what it is. Like Avi was saying, I remember being a young misdemeanor attorney and hearing about Debug and that they were involved in a case, and I was like, uh-oh, like, gotta be careful with this one, like, you know, and like Avi said, feeling protective, defensive, guarded over my case, over my client, over the way I'm doing it, feeling criticized. But like Avi is saying, like, it takes attorneys to think differently about that. Because if no one does it, then the ball never moves forward. So when I think about these definitions, like I said, it's a beautiful way to frame things because it makes me feel, in a sense, kind of like, oh, okay, this is why I went to law school. This is why I became a defender. But I also hear it as a call to action to always be mindful and remember to not necessarily accept the status quo. Just because things are being done a certain way doesn't mean that's the right thing. It's the right way that things should be done. So when I think about that definition, that's what stands out to me, is thinking radically and changing systems, not accepting systems the way they are. And there are many systems and many institutions within the criminal legal system that may need to be changed.
Yeah, I think with what Ashante was just talking about, if a client's family member, if a client had a child, right, in court, in like the recent old days, they would be put in jail. The client would be put in jail because the judges would say, bring a kid, go to jail. Because the judges didn't want to feel the cognitive dissonance of the consequences of their actions separating a family, right, against, they didn't want to feel that. So in order to not feel that, you just put people into custody and say, you brought a kid, go to jail. And they would, this is like a saying. And that's, recent, that's not like long ago, right? That's like 2012. So we're in a much different place right now in terms of talking about race. If you talk about race, Ashante said it's like dropping a bomb or throwing a grenade or whatever. That's right. The sentences would go up if you call out racism. And then there's organizing in the street. There's organizing among communities and schools, at the legislature. There's a Racial Justice Act. Now we're required, called to explain, understand, figure out, and advocate about implicit, express, right, racism in our system. So like there's these places of great strength that come from thinking not just about the client file, right, and how you're going to do the cross-examination or what you're going to say at the closing. Okay. So continuing our task of defining movement lawyering, there's a Professor Lopez's article, Rebellious Lawyering, and he contrasts, this is, I don't have the site, but it's a book. So he contrasts kind of non-movement lawyering. We're going to talk about what non-movement lawyering is, and then maybe that helps us figure out what movement lawyering would be. And I'm going to ask again for kind of reflection. So here's non-movement lawyering. They formally represent others. They litigate more than they do anything else, or maybe they transact more than anything else. Community education is kind of not critical work. Organizing is about maybe doing some mobilization work, like, but maybe not. The lawyers are the preeminent problem solvers. We can successfully fight subordination if professionals, specifically lawyers, are the leaders. That sometimes involve the people who are subject to that subordinating stuff. And lawyers, that's an honorable calling. They're political heroes. They largely work alone through their statements and their litigation to solve all the problems in society. Okay, so this, in contrast to that, rebellious lawyering, which might be connected to movement lawyering, is lawyering against subordination by working for and with communities. So we have to collaborate with other professionals and lay people rather than ignoring the help that they can provide. And we have to educate those, including the legal profession. So that's like the rebellious lawyering model. And then an article that we looked at before this talk was in the Clinical Law Review by Betty Hung. And it says, lawyering that supports and advances social movements, defined as the building and exercise of collective power led by the most directly impacted to achieve systemic, institutional, and cultural change. So what reactions do you have to that when you read that article before today?
Yeah, I can go first. So, yeah, I think in thinking about the article by Betty Hung, and then also the kind of the thoughts of Professor Gerald Lopez, I felt like my career as a public defender, I had this like really wonderful opportunity to do this community work. So like for 3 years, my full-time job was in the community, and was not necessarily litigating cases, was taking the lead from the youth at schools, or from folks in homeless encampments or folks experiencing different things. And we identified those as vulnerable populations, obviously the school to prison pipeline, and we focused on schools that were in geographic locations where there was significantly higher juvenile citations. And then obviously the unhoused population, if someone's formerly incarcerated, they're 10 times more likely to experience homelessness. There's the rates of disproportionality with respect to race and being homeless kind of mirror race and the criminal legal system. So there are a lot of reasons to focus on those populations. But it was just really awesome work, and it was awesome to be in the community without feeling like a lawyer, but not necessarily feeling like a lawyer. Being able to use, the law degree and my knowledge to transfer knowledge to the community. We did Know Your Rights trainings. I worked with youth as a mentor. I supported youth through expulsion hearings and restraining order hearings. And with the unhoused folks, it was like clearing warrants, but also Know Your Rights stuff. So it really just, there was a broad span, and it felt like it was directly responsive to what the community need was. And I think that was a real critical component to it. So I feel like it's cool to hear about rebellious lawyering, and it labeled that. And I feel like our office at the Santa Clara County Public Defender's Office was really kind of at the kind of cutting edge of that. And also I think the county for recognizing that and funding that position. So I think that's really cool. But I also think that's often what folks were doing even before that position existed. There were folks going out into the schools to work with kids and teach kids about their rights. We identified that as being important. There were folks that were going to resource fairs for folks who are unhoused from the office. And so I think there is a balance, as Avi was saying, when you have clients and you have a caseload, obviously you don't have as much time to go do those things, and you're balancing client-centered advocacy and things like the duty of loyalty and zealous advocacy and vigorous representation. So I do think that it's nuanced, but it definitely feels like things that we kind of do naturally, and I feel like I had the benefit and the blessing to be able to do it full time for a little while.
So when I read the article, I really thought of a story, and the story really, I think, embodies the intersection of movement lawyering with rebellious lawyering. And the story is this: when I was in 2021, I was a misdemeanor lead, and that means that I was the more seasoned attorney on a team of misdemeanor lawyers. So they were new lawyers that had either just passed the bar or recently passed the bar, and they were new attorneys, new misdemeanor attorneys. So I was tasked with helping them, and we did everything from arraignments to pretrial conferences to helping them prep their trials. So during the arraignment calendars, we started noticing something, and that was a new charge that kept coming up, and that charge was sideshows. The Santa Clara County, I think it might have been SJPD specifically, but an agency was in receipt of a grant to specifically address sideshows. And this was a very robust enforcement, to the point where from one day to the next, we saw not only these charges pop up, which hadn't before, or at least not very often at all, but the calendar was half full of these charges. The other thing that we noticed is that 98% of these individuals charged with sideshows were people of color. And when I say sideshows, I want to be specific. It was participating, but also observing. And the way that these cases read were, I stopped a car, all 4 people were in the area, and I'm arresting everybody for participation in a sideshow. Never mind the fact that there was a huge traffic blockade and people were sitting in traffic for hours on their way to wherever their destination was. So over the course of weeks, I heard countless stories of, I was on my way to dinner with my boyfriend. I was going to see my grandmother. I didn't know what was going on. I wanted to see what it was. It was a novelty. I was being nosy, so I got close to the action. I saw smoke. I wanted to see. And I also got some people saying, yeah, I knew it was a sideshow and I was interested. And they posed no harm. So what everybody had in common, except for maybe 1 or 2% of these individuals, was that they felt that they were targeted and dismissed by the police. They were targeted, meaning they happened to be there, the police came up, barely spoke to them, arrested them almost immediately just for being in the area, and 2, dismissed in that they tried to offer an explanation and that space was not held for them in any sort of way. So what happened is I went to the city attorney and I explained, what's going on? This is absurd. And he's operating under orders, so it was a bit of a push and pull over the course of a few days or weeks. And the offers went from community service plus a conviction to less community service, to very minimal community service, to, okay, just take the conviction. But I started realizing that some people did not want to take anything because they couldn't. They had a job. They couldn't afford to do 20 hours of community service. They were trying to maybe go to school, but mostly I saw people that had jobs and were like, I can't devote 20 hours of community service just because I was in the backseat of a car. But what I started realizing is some people did want to just take it and be on their way. So at one point, my team and I decided, you know what, we're going to set all of these for trial. And in order to do that, we needed a united front. So I remember a very hectic morning. 90% of the calendar was this charge. I took everybody into a little room, or a hallway, really, and I explained, this is what I'm seeing. Look around you. I see people of color. And this is what's happening to your peers, to each other. You can take the offer. That is your legal right. But you can also say no and set it for trial, and there is power in numbers. So empowering this community, even though some of them maybe were not people of color, maybe could do the 20 or 25 hours of community service. But when we all looked at each other and they looked at each other, it was really wonderful because they said, yeah, okay. And we were all on the same page and we all set it for trial. I set every single case for trial and they stopped, the charges stopped. So I see that as an intersection of both movement and rebellious lawyering because it is a non-conventional way to lawyer, right? I made sure that all ethical rules were followed in terms of attorney-client privilege and consent, but it is still a rebellious form of lawyering in many ways. But the 2 ways I'll highlight are the city attorney was not pleased. The city attorney was not pleased because he realized what I saw and he knew that it was not conventional but not illegal. And the judge was very displeased. The judge saw it as gamesmanship. She called it that on the record. And it was indeed not gamesmanship, right? It's just rebellious lawyering. So I think of that example. I thought of that example when I read the article because sometimes these things come up, and it came up recently with an RJA case where the judge offered my client a basically diversion plus some other terms, including community service, but diversion, and I needed to communicate to him the importance of sticking through the case because the case is currently pending writ review. He could have just said, you know what, I'm going to take my diversion. This is going to disappear off my record, and I'm going to be on my way. But a conversation with him, which involved educating him on the Penal Code 148 resisting, delaying, or obstructing, and the historical use of that penal code against people of color as pretext in order to justify excessive force, in order to justify stops without reasonable suspicion. And after we had that conversation, he was on board. So he rejected something that could have made his life a lot easier in order to help his larger community.
Yeah, I think that's from the morning, the discussion of impact lawyering versus direct services and how they collapse. That together with looking at it through some community lawyering or movement lawyering lens of somebody acting in solidarity to not take a dismissal so that he can litigate how charge has been kind of racistly applied in Santa Clara County is something that's worth being open to, that we don't get if it's just, I have a client in a case file, I don't talk to anybody else about anything other than my client in my case file, and I maximize the good things I can get in the criminal system as it exists. I had one just reaction on this, traditional lawyering versus movement lawyering, which is thought I would share, which is so in connection with the work of participatory defense, I got to sit in on a training. It was like a remote training with another public defender's office that was, they had a bail fund created. So a bail fund was based in the community. It was a community bail fund. They were figuring out ways to post low dollar bails for people and get them out, but additionally empower those people through community meetings, through organizing. So you would go to meetings with other community members, and then you could go to court and handle your case. And I thought I was just going to this training to talk about how cool participatory defense was, and it was like the rubber meeting the road in terms of a different model, the thing that I just talked about, the non-rebellious model, and a different way. And what I'm describing is the attorneys, right, being very what's the term? Basically, no one should be allowed to talk to my client about anything, including their case. My client shouldn't be told by a community member, ask the question, is this a good deal for you? Because that belongs, right, to the attorney-client relationship. So whether this is a good deal or not, that's for me to say with my client. Nobody's to ask questions about it. And the tension over giving up a little bit of control, which by the way is fictional. That's not correct. People can ask, our client's family members can ask if it's a good deal. That's not a violation of anything. But it was kind of a step of how do I prevent this from happening, right? Community members coming to watch court, right? Community members coming to watch me do arraignments and see me maybe not do a great job at 4:30. I don't know. So anyway, it was just illuminating the things that happen to you if you're an attorney doing really hard work, being very conscientious, being mission-driven, but having people question you. And I think it's worth it, but you have to get through those. Those folks, I think, had to get through those mental barriers. I don't think they did. But, okay, so now in this article we've been talking about, the Betty Hung article, she describes 3 essential threads that come from that definition of movement lawyering, which is about the building and exercise of collective power led by the most directly impacted to achieve systemic institutional cultural change. So I'm going to say them, and then we'll react to each one. So the first one is to be grounded in a place of humility that recognizes lawyers as but one of multiple strategies necessary to advance a social movement. So humility. 2, to act from a place of love that affirms the intersectional humanity of the whole person and entire communities in order to build movements together. So love, humility, love. And then 3 is to practice courage and be willing to relinquish our privileges in order to act and stand up for justice. So in thinking through this talk, did you all have any reactions to any of those ideas?
Yeah, cool.
Yeah, I think as lawyers, it is imperative we stay humble in recognizing that our role is very limited And I think for me, that really resonates with experts. So in my opinion, a good criminal defense attorney uses experts very liberally. So whether that means you want to educate the jury and or the judge on your client's background, maybe you get an expert on that, or linguistics, whatever it may be. So that has always, I think, been the case. I think I have always really looked up to attorneys in our office that use experts often, and that use is plentiful. I've always done that. But with racial justice specifically, it's crucial to use experts because we really need to educate the bench on what racism is, what it looks like. And some of you have heard me talk about this ad nauseum, but the legislative intent of the RJA, the reason why it's so a game changer is because it no longer is going to only address the obvious and overt forms of racism. So we're not looking for epithets anymore. The legislature recognized that bias, explicit, implicit, looks like racial coded language, racial coded conduct. So for all of that, I think we need experts. And in my work as the RJ attorney, I work with linguists, I work with sociologists, psychologists. I think that the more we go interdisciplinary with this, the better. So I'm humble enough to know that I am not the resource, the be it end all on bias, right? So especially with certain cultures, I mean, I may recognize some bias in the Latinx culture that my Asian colleague may recognize in their community, and that has actually happened. So with a Vietnamese client. So I'm humble enough to know, and I must remain humble enough to know that I don't know everything about bias, and I have to look for experts in our community, both in the academic sense, but also local experts, right? What is it like out there in San Jose to be a young Black man or a young Latino man? I need to know from the people that are experiencing it, not from the point of view of an attorney. And then do you want me to just go through the other ones?
Sure.
For love, I really think of the humanity in every single client that we serve. I really think that, I think there are different schools of thought on boundaries and how much we should open up ourselves to thinking about our clients and things like that. But I always think of, what if this was one of my family members? What kind of legal representation would I want them to have? And leading with that, I think I lead with love. And then lastly, courage. Courage is one of the most important parts, I think, of all of the types of lawyering we're talking about, because you are standing up with someone during the worst time of their life, and you are standing up with them in front of a system, a judge, a district attorney that just foundationally disagrees, historically has participated in the oppression of your client. And it takes courage to talk about race in the courtroom. Ashante mentioned that it has always been really taboo or stigmatized to talk about race, and I've experienced that. And even now, as the racial justice attorney, when I talk about race, it's still very uncomfortable, and people still go into this very defensive mode of, I'm not racist. And it's like, yeah, relax. It's all about implicit bias, no intentionality required. But people don't think that, right? People immediately want to prove themselves. And that's really a disservice to themselves and to the community, because we all hold biases. So having courage to talk about these issues, having courage to go above and beyond explaining to your judge or the prosecutor that you are working with, going above and beyond of just merely explaining why a different offer should be given, but really explaining your client's story and humanizing them and taking that space, taking that time to tell their story, because their story does not get told.
That's awesome. And I'm still like tripping about the sideshow story. That's pretty cool. But I was thinking about, I was listening to Karina go through, and I was also thinking about experts in a way. Just, I think, I can speak for myself. I went to law school. I feel like I know something. I've been an attorney. I feel like I know something. But really, like, what I learned is when I walk into that first interview with my client is the expert at that particular time. And so I think, just like Karina was saying in all these other areas, definitely humbling oneself and knowing that, hey, it's time to kind of ask for some guidance from someone else who has a little bit more information in this field. But I think from ground zero, just recognizing that maybe we're not as self-important as our ego is telling us that we are, and that our client is the expert in the room. Someone really important to me who was also a public defender was telling me a story about when she qualified her client as an expert on the stand. The issue was whether or not the client's car could do a burnout. And so she was courageous enough in that moment to take this risk to see if I can qualify my client as an expert in whether his car could do a burnout. And he knows his car better than anyone else. And so I think humbling yourself in that way and really recognizing that your client, going into the case, going into the situation in your client interviews and listening first, as opposed to talking to someone. And there's a lot of, I think, rhetoric that can sometimes creep into the work in terms of whether we know better than our clients about certain decisions and things like that. So I think when I think about the first piece of humility, I just think about being really careful and recognizing where you're at and being mindful to listen first and treat your client and person you're serving as the expert. With respect to the intersectionality, I think I kind of go back to kind of what Avi was saying about participatory defense, but also just like family. And because when I read that, I thought about the intersectionality between the individual and the community. And just traditionally, when I think I started my career, I saw family involvement as being more onerous to the work, because I have this to do, and now the mom's calling me. She wants to know what's happening with the case. And it's horrible to say it out loud. But I think as time has gone on, I've realized how important it is to have family involvement for your clients. Oftentimes, clients don't have any family to support them. So when you do have family involvement or community involvement, and the more you can call upon them, because they may be experts too in your client. They may be able to help you develop trusting relationships with your client. And they may help you to understand a little bit more about how you can successfully impact the case. I think it's critical to honor that intersectionality between the individual and the community that they come from. And then the final thing, courage. I think the job is hard. I think doing the job is courageous. Just by signing up to do the job, it's a mark of courage. But I think there are always opportunities to be more courageous, and there are always opportunities to. Betty Hung talks about relinquishing privilege. And that's kind of what it feels like. It's a privilege to go to law school, to have a law degree, to be in that position. And so what does it mean to speak out when something's wrong, or to do like what Karina did, where she was like, hey, let's get everybody together, and I don't care who gets pissed off. This is the right thing, because this is wrong. And so I think just keeping that in mind. The job in and of itself requires a lot of courage. But I think every day that you do the job, there's an opportunity to be courageous and to keep in mind the privileges that you have and the reasons why you make decisions you make, and make sure that you're putting your client in whatever that movement is first. So those are my thoughts.
Yeah, the only thing I'll say is that these are good things, right? It's good to be grounded in a place of humility, generally speaking. It's good to have kind of concern and even love for intersectional humanity. And it's also good to practice courage. In the courage part, for me, it's not the lawyering, right? It might feel like it's doing those things that feel uncomfortable, but that are actually just make life so much easier. So telling the truth, keeping it real, just saying whatever you think, that's the world we're in, dude. I just feel a lot better when I'm doing advocacy for on a pretrial release, right? Just telling this person shouldn't be in jail. There's all these options. think about what's going to be happening to them. Like, that's just something that we wouldn't say before, but so is it courageous to just say what's real? Is it courageous to say a police officer did something that was like overtly or just implicitly biased and have them be mad about it? I don't know. But I think we should do it more. And I love what you said about the clients as the experts. That's absolutely true in every dimension of the practice for criminal defense. So it's time. Okay, so let's have questions, comments, reactions. The one subject that we haven't talked about, that if you have questions about, I'd love to talk about, are the connections and disconnections, or the mismatches between movement lawyering and public defense models. So if anyone has any reaction to that, I would love to hear what comes to mind.
Thank you, Daniela. Hi, I'm Juliette Brody. I run our community law clinic here at the law school, and I'm not a public defender. I'm an eviction defense lawyer, but I talk to my students all the time, and Ron and I talk all the time about the analogies between the systems that we work in, and that public defenders are sort of our closest cousins in terms of, but it does go, Avi, to this question about the tensions between individual defense work, whether it's eviction or misdemeanors, and a movement, right? Because in both of the systems that we're in, we are representing individuals who are on the wrong side of the V. I'm really sorry I couldn't be here for this morning's affirmative litigation panel, because maybe some of these themes you talked about. But, you know, we are like, the landlords are plucking my clients one at a time, and the government is plucking your clients one at a time, and by definition, putting our clients on defense in an individual matter. And how to turn that into movement. I mean, that's why this story about taking everybody on the calendar into the hallway and saying, like, let's all commit for trial. We talk about that all the time. Like, why are we taking these shitty deals every day and not just, let's confirm everything for trial and see what happens when we try and break the system, right? But I think I would just love to hear any thoughts about those sort of system design problems when we are representing individuals in systems that are characterized by economic and racial historical exploitation. And, you know, if we could all get in that hallway with the sideshows, that would be amazing.
Well, just one, I'll maybe get us started, because I think about this stuff, like confidentiality, individual decision-making, you know, the dynamics of the system that are set up to punish people for doing this stuff. So coercive plea bargaining, you know, sentencing, a trial tax, right? How do you reconcile a trial tax with telling people they should go, you know, collectively to trial, or you should, you know, say no to this, or, and I think that it's about, like, for me, it's about following all those things, absolutely, right? But also talking to the client about options that are not, let's just keep this to ourselves, and thinking through. So for the participatory defense part of it, it started for me of connecting family members. So it was actually a really nice connection, because instead of telling the family members everything that's happening for the case, I had people who are organizing families of system-affected people to participate meaningfully in their cases. But then it grows in some way. So I think, like, client consent, informed consent, discussing what's ahead, how do we tell your story largely, it makes a lot of sense in a bail context where we're bringing lots of people together to show that the community is here in a criminal case. And then being kind of truth-telling about what those negative system effects are, kind of naming them so you can minimize their likelihood, like saying in court, like, this person, you know, this case is a misdemeanor. It should be treated as a misdemeanor, but it's treated as a you know, 10-year prison case, right? And it should be treated as a misdemeanor, and that shouldn't change because community members are here in support of the people. And then empowering them to do whatever they're gonna do, right? And not being the director of, you know, you go here, you go there. They're gonna do what they're gonna do anyway, by the way. Like, if they're engaged, they're gonna do that anyway. So that's just on the participatory part. That's not on the kind of organized part.
I have some quick thoughts. What was your name again? Sorry. Julia. So I think there's a lot to be said. Avi, and he said it to me, like in the hallways and on the walks to court, like injustice happens often in empty courtrooms. But as a community outreach attorney, I went in to observe eviction court. And one of the pushes we were trying to make was to establish right to counsel for eviction defense in Santa Clara County. But what I observed was troubling to me because folks were largely represented. I think it's some crazy number, like 90-something% of folks, at least in Santa Clara County, were unrepresented. But the landlords had attorneys, and they were doing trials, like with rules of evidence, and so it was just incredibly lopsided. And I wanted to like jump up and like, object. But I think I didn't know until I sat in the courtroom and saw that. So I think one way, just thinking out loud, is that maybe it's not something the attorney needs to do necessarily, but having other people come to observe and see what's happening, it might make folks feel some sense of accountability in the courtroom that are making those decisions. And that may be, the start to whatever the wave is of that social movement to make it build. So that's one thought I had, is that was a moving experience for me to go and to realize, whoa, this has just been happening, and I had no idea that things went down this way. So I think the fact of bringing folks in to see how bad it can be, I think can be really, really important.
Yeah, the one thing I will add is that I think an important practice is to keep informed. So keep making sure that you are understanding the trends and patterns. As PDs, we can be very siloed if we choose to be. So, for example, an attorney at our office can choose to just put their heads down and go through trial after trial. And we have meetings, but they're not exactly mandatory. And if you have trial, that's going to supersede any meetings. And the reason I bring that up is because at these meetings, I sometimes attend as an RJ attorney, and you hear about trends and you hear about patterns. You hear, hey, this specific prosecutor is giving this offer for this charge. Or, hey, this specific prosecutor has been agreeing to home detention. And then another attorney will hear, oh, well, your facts are similar to mine. That's not my experience. So I think there's power in communication, and I think it's very important that as attorneys, we understand what cases are going for, because that's going to be powerful in terms of leveraging these offers and attorneys against each other, prosecutors. And I'll share a tidbit more about my sideshow story. In the middle of that very chaotic morning, a private attorney came in running with his briefcase. And he called a case. He had the one private attorney case on the calendar for a sideshow, and he was elated to take the offer because he had no idea. He didn't look at his case in the context of the big picture that I had, right? He didn't have access to the calendar overall. He wasn't privy to the conversations that had happened the days prior or even that very morning. So when he was so joyful in accepting this offer, I took him to the side and said, hey, no. Like, this is not a good offer, because you don't know what a good offer is unless it's contextualized, right? So I think as attorneys, irrespective of what kind of practice you are in, it is imperative that we stay in communication. I love listservs. I'm on like 4 different listservs. And I love attorneys speaking with each other. I think it's very powerful for attorneys that serve the public interest and communities that are oppressed to constantly be in communication with what DAs and what agencies are offering so that we can use that information to further defend our clients.
Hi, thank you for your talk. It was very helpful. My name is Claire, and I'm a public defender in Seattle. And one thing that I think would be really great to bring, not to bring there, but to do more of there is participatory defense. And I've seen for years that we try but don't quite have the expertise that I think you guys do in Santa Clara. And having seen Avi do it back when I was in law school, we actually had an attorney from my office who brought SV Debug to Seattle as an expert, and it was really, really helpful. And so then we tried to do it again recently, and our office was like, there has to be someone in Washington that can do this, right? Like, we don't want to pay the expert fees to bring these people in from California. And while we have great community partners, there isn't quite that role. And I'm curious, like, if you have advice for very practical steps that we can take in the absence of those specific supports to still bring some of the participatory defense.
So just one thing that comes to mind is Debug's work setting up participatory defense hubs all over the country. And so there might be a hub in Washington State that might not be in Seattle, and that might be a place to look for people who have already done some like infrastructure building. The thing that's, it's like a two-way street too, because when they're setting up these hubs in order to bring community power into criminal prosecutions, criminal defense cases, they're also talking about, what a public defender is, right? As opposed to, which really helps our practice, right? If we're not met we already start with a major trust deficit that's like understandable and warranted and should be present, but it can really help people understand what our role is and how we're there to help and what limitations exist, right? When you have basically not know your rights, but kind of understand when you have a community organization that's assisting, supporting, but then also telling you this is, maybe why the attorney is limited on what they can say about, the legal strategy. So I would look for those hubs. I would talk to Debug about those hubs. And then I would look for the organizations that are already doing the work. Like in Santa Clara County, we have Standing Up for Racial Justice, which has been doing work against kind of further new jails and new facilities. We've had organizations that have been doing work against police in schools, and that has to be the case in Seattle. There must be the case in every one of these cities, people who are showing up. And talk to those people, go to their meetings. Just introduce yourself to them, and then they'll have somebody affected by a case, and they'll show up, and things will go from there. Do you all have anything on that?
I would just add that I can get you the name after, but I recently met a public defender and a wonderful man who founded a nonprofit. You might know it. I can't remember the name. But he served, I want to say, 32 years in prison. And while he was in prison, he was studying up on racial injustices and became really passionate about becoming an expert and also becoming an expert in data. So the reason why I met with him was because they built an incredible data tool. I don't know if you already use it, but it's phenomenal. So it would really be helpful if you are going to do RJA cases in the future or whatnot. But he is really passionate about this subject, and he's in Seattle. So he's really passionate about using people that have been system impacted to serve as experts. So maybe you can get in contact with them.
The only thing I would just add quickly is, maybe this isn't helpful, maybe it is, but to think outside the box in terms of like, who is your client's community, this particular client, like what church do they go to? What school did he go to? Did he have a favorite teacher? And maybe those kind of points of contact can, well, not obviously they're not going to be Debug, but they may be able to build something in each individual case specific to that client. I think the beauty of Debug is that they kind of take on a lot of that load, which is hard to do as a defender. But there may be other ways to tap into similar support networks that can advocate on behalf of your client, specific to your client's circumstances. And maybe once you do that, you can develop kind of a network of those organizations or those communities.
Hi there. My name is Stasia. I'm a current 2L here at Stanford, and I'm coming. First of all, I just want to thank all of you for being here. This has been a very energizing day, and I'm super excited. From the perspective of an aspiring public defender I'm from a pretty rural area in a state where their political circumstances are very different. And so I'm wondering what advice you have to sort of like bring these movement lawyering lessons back to other communities, because it seems like there's a lot of cool institutions that y'all have been tapped into. And I'm just wondering like what institutional supports you all have found the most helpful, and like when you're envisioning like going to a community that's kind of like starting from scratch in this sort of movement, if you have any lessons from your work seeing these movements develop in this area that you think would be helpful.
Do you have something from your work, your current work of, because so we're in Santa Clara, but you're connected to so many other offices in different environments that might have different approaches or different resource circumstances. Does anything come to mind in that question?
Yeah, I mean, I think it's challenging. I'd start with that.
Yeah.
The state of California is, the responsibility of providing indigent defense services is delegated to the counties, and each county does it differently. Each county has a different population size, different politics. And so some counties have full public defender systems, some have contract systems. And the way the defense services is delivered can vary pretty greatly. So I think it's hard. I think I don't know. My answer would be that yeah, it does kind of depend on the institution and the structure that's in place. But really, like a lot of folks that I've talked to, it just the right people can make a difference. So I think you're doing the right thing. You're learning, and then you take it back, and you go back and you get a group of folks who were charged with sideshows, and you like rally them together, and you do these things, and then I think you tell other people about those things too, and make sure, like Karina was saying, I'm kind of embarrassed. I didn't know we worked in the same office. I didn't know that she did that. Like that's pretty huge. But I think to make sure that those things are shared amongst the people that you work with, I think all of these things that we talked about in terms of being humble, recognizing the intersectionality of individuals and communities, and being courageous, which it sounds like that's what you're doing by already committing to taking this back to to wherever you're going to work. So I think it starts with the heart that you bring to the work, and then just keep going with that. But yeah, I do recognize that it's easier to do certain work in certain areas because of the infrastructure, the politics, and the support than it is to do it in other areas. And I think to not recognize that would be untruthful. But I think you do what you can.
I would also start with a grassroots approach. So at its most simplistic form, I think you start with Court Watch. I think that it would be really impactful to explain or remind people that per the Constitution, anyone can watch a hearing or a trial, and I think transparency is often the road to accountability. So I don't know how small of a town we're talking, but I would honestly just try to get the word out that you're starting a Court Watch program. And I would try to get as many citizens as possible to just watch. And what I think is really powerful about a Court Watch program, especially if you start out in baby steps, is you don't even really have to have an ideology, right? It doesn't have to be dogmatic in its inception. It can just be, let's just watch court. And they will see for themselves the injustices and the disparities. And then all of a sudden it's, okay, well, collectively, how can we help this? And then you have a movement.
I have a question. My name's Carly. I work here. It seems implied that we're excluding judges from the concept of the movement. And I'm wondering whether you agree with that statement. Are we excluding the possibility of taking over the judicial appointments process, the judicial elections process? Like, should we be thinking broader to take action based in communities to make sure the bench looks like this panel and thinks like this panel?
Yeah.
So will you please all be judges? And if not, why not? Thank you.
Okay, I think I'm going to close the panel with that. I am usually a stickler on time, but this is such a great panel, and there will always be a little more time for this for us this afternoon. So I really want to thank the panel. Again, just as a reminder for those of you who may not know these panelists, Avi Singh, Supervising Deputy Public Defender for the Research Unit at Santa Clara County Public Defender's Office, Ashante Mitchell, who is a staff attorney for capacity building in the Office of the State Public Defender, and Karina Alvarez, who's a Deputy Public Defender and the Racial Justice Act attorney at the Santa Clara County Public Defender's Office. Thank you all so much.
Thank you.